Assalamualaikum and hi everyone. Today will be presenting on the topic of Article 5, Clause 1 of the Federal Constitution.
So, in the case of Maria Chin Abdullah and Ketua Pengarah Immigration, in this case, Maria Chin Abdullah had intended to travel to South Korea in 2016 to receive a Human Rights Award, but was barred from traveling overseas due to the travel ban. She was given no prior notice or reasons for the ban, nor an opportunity to be heard. Maria then challenged the immigration authorities' action, claiming that the travel ban had violated her fundamental rights to personal liberty under Article 5, Clause 1 of the Federal Constitution.
So, there are two constitutional issues in the case of Maria Chin Abdullah and Ketua Pengarah Immigration and another. The first one is whether the right to travel abroad falls within the meaning of personal liberty under Article 5, Clause 1 of the Federal Constitution. And the second one is whether the decision to restrict this right without reasons or procedural fairness was unconstitutional. So, in this case, the court held that Article 5, Clause 1 of the Federal Constitution does not include the right to travel abroad. The Federal Court majority reaffirmed the principle from the case of Law Wycombe, holding that the right to travel overseas is not a guaranteed constitutional right, but rather a principle governed by the law. Thus, the restriction of overseas travel does not amount to a breach of personal liberty under Article 5, Clause 1 of the Federal Constitution, especially when done within administrative power granted by the law. So the ratio decidendi in this case, there are two views. The first one is the majority views, and the second one is the dissenting views. So for the majority views by the judge Abdul Rahman and others, the majority did not accept that Article 5 Clause 1 includes the right to travel overseas, relying on the precedent in the case of Law Wycombe, as it was held that travel abroad is a privilege and not a right under Article 5, Clause 1. The right to personal liberty must be interpreted within the scope permitted by the law, and travel abroad is not a guaranteed constitutional right. Therefore, Article 5, Clause 1 was not violated even if the travel ban was questionable. So, for the dissenting view by Chief Justice Tengku Maimun and Federal Court Judge Nalini Padmanathan, the dissenting judges took a broad interpretation of Article 5, Clause 1, affirming that personal liberty under Article 5, Clause 1 includes the right to travel abroad. The federal constitution must be interpreted to protect fundamental rights. The travel ban has infringed Maria Chin's right to personal liberty. The right to travel overseas is closely connected to personal freedom, especially because she had a valid passport and was not found guilty of any crime. Since there is no specific law authorizes such a restriction, the ban was unlawful and violated Article 5, Clause 1 of the Federal Constitution.
Letitia Bosman arrived at Senai International Airport, Johor. Custom officers found 1.9 kg of methamphetamine hidden in the sidewalls of her suitcase. She claimed she didn't know the drugs were there and said a man in India had given her the bag. She was then charged with drug trafficking under Section 39B of the Dangerous Drugs Act 1952, which carried a mandatory death penalty at the time. The court found she had control and knowledge of the drugs and convicted her.
So now I'll be explaining about the issues, court decisions and ratio decidendi. For the issues, whether the mandatory death penalty under Section 39B of the Dangerous Act 1950 was unconstitutional, whether the mandatory death penalty infringed the rights of the applicant of fair trial, whether denying an accused person the right to plea in mitigation due to a mandatory sentence contravenes the right to a fair trial under Article 5 Clause 1, whether the mandatory death penalty was imposed arbitrarily, whether the mandatory death penalty was cruel and inhuman. So for the court decision, the federal court dismissed the applicant's claim and upheld that the mandatory death penalty under the section was constitutional. Both sections also was valid and did not infringe the rights of the applicant under the federal constitution. The appellant failed to show that the provision were inconsistent with Article 5, 8 and 121 of the federal constitution. Under the federal constitution, the power to determine the measure of punishment is at the hands of the parliament. The court could not at its own pleasure impose any sentence it wished if the law did not permit it. For the ratio decidendi, while the Article 5 Clause 1 guarantees the right to the life of the person and personal liberty, however, it's not absolute right, as the person can be deprived of their life or liberty, but only if it's done according to a law. Mitigation is generally a part of sentencing. Since it is a mandatory death sentence, mitigation has no effect. Court have no discretion to impose lesser sentences when the parliament mandates a specific punishments. Thus, there is no violation of constitutional rights if the deprivation of life, liberty, or the rights to mitigation is done in accordance with a valid law. A mandatory death sentence is not arbitrary or unconstitutional under Article 5 Clause 1 of the Federal Constitution, as long as it is imposed pursuant to a valid law enacted by the parliament. The absence of judicial discretion in sentences does not render the law arbitrary, provided that the law is clear, precise, and pursues a legitimate legislative objective. Mandatory death penalty was considered valid and constitutional on the grounds that the federal constitution does not contain any provisions that prohibiting cruel, inhuman, or degrading punishment like the constitution of other countries. All in all, since the death penalty was validly enacted, it does not contravene the rights of the applicants under Article 5 Clause 1. That's all from me. Thank you.
Moving on to the case of Kengadaran Ramsamy and Menteri Kewangan Malaysia and Anwar. So in this case, in 2019, the government had introduced the Departure Levy Act 2019 in the pursuit of Article 96 of the Federal Constitution, which explains that tax and rates were only levied if provided by federal law, and the Departure Levy, Rate of Departure Levy Order 2019, which imposes a tax on anyone travelling abroad. R. Kengadaran Ramsamy, the plaintiff, who had been planning to travel abroad, was required to pay this levy. In the High Court, the learned judge had agreed with the defendant's submission of how Government of Malaysia and ORS and Loh Wai Kong case is still relevant. Thus, the two laws challenged as unconstitutional by the plaintiffs is deemed constitutional in this case. However, dissatisfied with this decision, the plaintiff had challenged the decision by going for an appeal, saying that the Departure Levy Act 2018 and the Departure Levy, Rate of Departure Levy Order 2019 violated his right to travel abroad under Article 5 Clause 1 of the Federal Constitution.
Thank you, Suha. So now let's move on to the constitutional issue, which is whether the Departure Levy Act 2019 and the Departure Levy, Rate of Departure Levy Order 2019 violates Article 5 Clause 1 of the Federal Constitution. So the ratio decidendi and also the legal principle of this case has stated that the Court of Appeal judge held that Article 5 Clause 1 of the Federal Constitution protects only the freedom from unlawful detention and related personal liberties and not the right to travel overseas. So the court viewed that although there was a new case, Amanuddin Atanza and public prosecutor, it did not overrule the case of Government of Malaysia and Loh Wai Kong, therefore making the latter case valid and relevant to this case due to its similar facts and issue on the case of restrictions to travel abroad. Therefore, with the court's decision and judgment, we are looking at the Courts of Appeal who upheld the High Court's decision and the implementation of Loh Wai Kong's case, thus dismissing the plaintiff's appeal. Therefore, the Departure Levy Act 2019 and the Departure Levy, Rate of Departure Levy Order 2019 is not violating Article 5 Clause 1 of the Federal Constitution and is enforceable, valid and constitutional. The next speaker.
Indira Gandhi, anak perempuan Muthu, was married to Padmarasan, anak lelaki Krishna, and had 3 children. Her husband had left and later converted to Islam. A dispute arose when her husband converted the children to Islam without her consent and obtained the custody of the children from the Shariah court. However, the children were not present before the registrar and did not utter the 2 clauses of the affirmation of faith required by the Administration of the Religion of Islam, Perak Enactment 2004. Indira was granted custody of the 3 children and her divorce petition for civil marriage was allowed. She has successfully challenged the unilateral conversion in the High Court, but however, the Court of Appeal ruled against her.
Thank you, Suha. Next, let's move to the constitutional issue. The first issue is whether High Court has the exclusive jurisdiction to review the decision made by the Registrar of Mu'allaf. Second issue is whether a child of marriage under the civil marriage who has not attained the age of 18 years must comply with Section 96, Subsection 1 and Section 106, Subsection B of the Administration of the Religion of Islam, Perak Enactment 2004 before the Registrar of Mu'allaf may register the conversion to Islam of the child. And the last issue is whether the parents of a child of a civil marriage must give a consent before a certificate of conversion to Islam can be issued. Next, I will explain the court's judgment. In this case, the Federal Court allowed Indira Gandhi's appeal. Federal Court held that the certificates of conversion issued in respect of Indira Gandhi's children were quashed and it was declared of both parents must consent to the religious conversion of a child. Thus, the High Court has jurisdiction to hear judicial review application. The last part is, I will explain about the legal principle or ratio decidendi based on the court's judgment. Article 4 Sub 1 of the Federal Constitution affirm that the Federal Constitution is the supreme law of the land. The Federal Court emphasized that Article 5 Sub 1 of the Federal Constitution protects for parental right and freedom from unlawful state action. The Federal Court also interpreted that Article 12 Sub 4 of the Federal Constitution, which states that the religion of a person under the age of 18 years shall be decided by his parent or guardian. The court further held that unilateral conversion would lead to unconstitutional discrimination under Article 8 Sub 2 of the Guardianship of Infants Act 1961. As per Article 121, Sub 1A of the Federal Constitution, civil court have no jurisdiction over matters within the jurisdiction of the Sharia court. However, civil court possess the exclusive jurisdiction to review administrative action, including those from Islamic religious departments. Next, I will pass to the next presenter.
Lastly, in the case of Alma Nudo Atenza and public prosecutor, in this case, Alma Nudo Atenza, who was a Philippines national, was apprehended at Kuala Lumpur International Airport, KLIA, for the concealment of cocaine in her suitcase under Section 37A of the Dangerous Drugs Act 1952. She was found guilty as charged and sentenced to death. Alma had then challenged the constitutionality of Section 37A, saying that this had violated her constitutional rights under Article 5 Clause 1 of the Federal Constitution.
Thank you, Sulha, for the facts of the case. Now, we will move to the constitutional issues that we need to observe in this case. So, the first issue is whether Section 37A of the Dangerous Drug Act is unconstitutional for violating the Article 5, Clause 1, read with Article 8, Clause 1 of the Federal Constitution. That's the first one. Second issue is whether the leave of the Federal Court is required in order to challenge the constitutional validity of Section 37A of the Dangerous Drugs Act. Now, I will explain to you about the court judgment in this case. Exciting, right? So, the first one is the Federal Court held that the Section 37A of the Dangerous Drug Act was found to be unconstitutional and violated the Article 5 Clause 1 of the Federal Constitution. Why is said to be like this? It is because the article or the Section 37A of the Dangerous Drug Act was placed an unjust legal burden on the accused to prove that the innocence. Second, the court also emphasized that the application of double presumption was disproportionate to the objective of curbing the issues of drug trafficking. Therefore, it also had violated the Article 8 Clause 1 of the Federal Constitution. And the last one is, the court also rejected the argument that the appellants required leave of the federal court because leave is only necessary when challenging the parliamentary legislative competence, not when it is alleging inconsistency with constitutional right that is said in this case. Now, moving on to the last part of this case, which is the legal principle or ratio decidendi. So what are the legal principles and ratio decidendi? Why the court decided to that judgment? The first one is the presumption of innocence. This principle guarantees that no person shall be deprived of life or personal liberty except in accordance with the law. And here, the court emphasized that the criminal conviction must be based on beyond any reasonable doubt. By imposing a balance of probability on the accused to rebut this presumption, Section 37A of the Dangerous Drug Act reversed this principle. And this one considered to be an unconstitutional under Article 5, Clause 1 of the Federal Constitution. Next, the doctrine of proportionality. This doctrine guarantees that equally and equal protection of the law, meaning that everyone, every person, regardless of the religion, regardless of the race, white skin, black skin, and everything, everyone must be treated equally when it comes to the law. So, in this case, the federal court held that the laws that interfere with fundamental liberty must be proportionate to their legislative objective. However, Section 37A of the Dangerous Drug Act was not proportionate to its purpose of combating drug trafficking issue because it imposed an excessive and unjust burden on the accused to prove the innocence of the accused. That's all for my part for this presentation. Thank you.